between scholars of the Mexico-US border and the Balkans journey to the EU. This group recognized a set of shared policies of border externalization that seek to prevent migrants, including asylum seekers, from crossing borders into the EU or US, where they have the right to ask for protection from persecution. Borders are effectively redrawn and policed elsewhere through practices such as illegal pushbacks, offshoring of asylum processes, detention in other countries, and policies such as Remain in Mexico, Title 42 expulsions, the Pact on Migration and Asylum, and temporary statuses like the EU Temporary Protection Directive. You'll be hearing much more about these today. Our team wanted to take an expansive view of border externalization, considering where, for example, the transportation of migrants to so-called sanctuary cities, New York, Boston, Martha's Vineyard, and the funding of so-called securities or development projects in other countries fits into this set of strategies. And our seminar series will also explore the ethical challenges, natural landscapes, economies, protests, and forms of creativity that emerge within EU and US borderlands. We ask, what unique and common histories brought border externalization strategies into existence? What are the normative and ethical implications of these strategies, and how might they inform our understanding of liberalism and democratic theory? What is the current impact of these policies on those living in the border regimes? We hope to center refugee voices and narratives, exploring the way migrants respond to border violence and legal precarity through artistic and cultural expressions. We consider this space is inhabited by migrants and the manifestations of various forms of violence, but also the models of care, particularly access to healthcare, implemented at these sites. By centering ethics, history, arts, culture, race, and ethnicity, gender, and technologies in a conversation often dominated by policy approaches, we hope that our seminar will introduce new ways of understanding borders, new effective relationships to human mobility, and new languages for engaging one of the most pressing social justice concerns of our time. What if we refuse to imagine human movement as a crisis? We were able to demonstrate to the Mellon Foundation for the Arts and Humanities that these fields are fundamental to the studies of border regimes, forced displacement, and humanitarian crises, and that humanistic perspectives will be crucial as we seek to generate ethical solutions or reframe the debate entirely. For this first event of our seminar, we hope to feature the incredible work being done by scholars here at Boston University through a set of quick 8-minute lightning talks, followed by discussion and more conversation over lunch. To that end, I will briefly introduce our speakers with their simple affiliations and invite them to come up and talk here. Then we'll have lots of time for conversation. I have a slide here pointing to other seminars in the series. The next one is in Texas, Migration to the US Southern Border, Migrants, Hosts, Politics of Protest, also generously supported by the University of Texas and our Center for Innovation in Social Work here at BU. And our keynote, Dr. Ronald Ryall, whose teeter-totter wall pictures here, is going to be incredible and going to be Zoomed. So even if you don't happen to be in Texas in March, please join us on Zoom for that event. April 6th, back here, Migrant Journeys, Lives and Deaths in Transition. And then April 24th and 25th, which is the Center on Forced Displacement Annual Conference, keynote Abdul Razak Gurna, who won the 2021 Nobel Prize in Literature, and our seminar, Border Cultures as Spaces of Resistance, Activism, Art, and Hope. So please join us this semester, and then we'll have Sawyer seminars throughout next year as well. Okay, our speakers today. First, in a team effort, as they often write as a team and teach as a team, Kaya Schilde, who is Jean Monnet Chair in European Security and Defense and Associate Professor of International Relations at the Pardee School of Global Studies and Director of the Center for the Study of Europe, and Nora Laurie, Assistant Professor of International Relations at the Pardee School of Global Studies. They'll be speaking together. followed by Isabella Trombetta, previously introduced as our postdoctoral associate at the Center on Forced Displacement. Susan Akram, clinical professor of law and director of BU Law's International Human Rights Clinic. Mark Starella, professor of the practice of diplomacy and director of the African Studies Center at the Pardee School of Global Studies. And finally, Jeff Rubin, associate professor of history in the College of Arts and Sciences, research associate for the BU Institute on Culture, Religion, and World Affairs. Thank you. And now I'll turn it over to Nora and Kaya. Which of you wants the?
I can take the handheld if you want this.
Okay, great. So this one just here.
Okay, I'll turn it.
And that one you just have to click on.
Okay, and then
Your slides are
great,
here.
wonderful.
Yep.
Okay. Hi, I'm going to try not to trip over here and just be aware of my surroundings. Okay. All right, so do you want to start?
Yeah,
Okay,
just to say good afternoon or good morning. It's really a pleasure to be here. And initially we were going to do separate presentations, but we co-author a lot together, and we have a piece specifically about externalization in the high seas. And so rather than going fully into that piece, because we have other scholars here and colleagues who will be looking into some of those details, both legally and also in terms of migrant search and rescue and this interplay between governments and search and rescue, we thought we would just take a minute to step back and think about what are borders. Why does externalization get used? What are the strategic advantages of externalization? What is motivating states to take this aspect to border control? And what are some of the impacts of that? So just to kind of start us off, when we're talking about border externalization, who's externalizing borders? It's precisely the states that have core sovereignty over territorial decisions over who is allowed to enter the territory and reside there and for how long. And so taking John Torpey's invention of the passport has this beautiful framing of thinking about modern states as being entities that monopolize the authority over legitimate movement, and as this being a key aspect of sovereignty alongside security and monopolization over legitimate violence, which is often used as a more common, the Weberian approach of kind of focusing on security. So authorization of mobility is arguably even more connected to state sovereignty. And so one of the things when we think about how states are protecting that sovereign right is to focus on restriction. But border control is not about restriction, it's about filtration and increasing discretionary power over who can enter, who you want to enter, and who you don't. And so a lot of what we're trying to think through with this externalization is understanding how these aspects of border controls remotely are also about filtration, accelerating, so both delaying, obstructing the entry of certain undesirable migrants, typically labor migrants or those seeking humanitarian protection, while accelerating pathways for business and business people, tourists, and especially high net worth individuals. And so I find that Ayelet Shahar has this beautiful book called The Shifting Border. And what she does is say, look, we expect that these territorial borders are fixed, right? We know where they are. There might be contestation about where that specific border lies on a map, but borders are fixed in these territories. And she argues that thinking about contemporary migration control, it's not about where the migrant meets the border. It's not that the border is here and the migrant meets the border. The border is being pushed out to meet the migrant way before they even begin their journey in sometimes. And so, in thinking about kind of breaking down aspects of border control, it can be helpful to think about border zones where you have what we kind of typically think of as the space of a border, but also exterior controls, forms of remote controls, which are where the border is kind of being pushed outside the territory of the state, or interior controls. And interior controls simply mean when the border clings to the migrant, clings to the individual internally, when you have an apparatus in place, an identity management infrastructure that connects legal status to a whole range of resources and membership rights in a state, such as access to healthcare, landlords, rents, schools. So a whole range of private and public institutions that check legal status internally is also border control. Though that's interior control. And so one of the things, I have a response in that book with her, where she's really kind of thinking about the spatial dimensions. And I also kind of look at the temporal dimensions of borders. And so we're not going to be talking so much about that today, but just to sort of think about how not just space is used strategically, but also time, is thinking about, what matters when an individual it comes to accruing citizenship rights or membership rights is not how long an individual has actually resided in a territory, but how that residencies, how that time is counted and converted into rights by the state. And so by pegging different rights to different legal statuses and counting the time of different statuses differently, states increase their discretionary power by delaying, suspending, or on the flip side, accelerating time for migrants. And so temporary worker programs, temporary humanitarian protection are examples of how we count people as temporary, even if they've been on these temporary statuses for decades and generations, right? So that's one temporal aspect of slowing down or suspending time altogether when it comes to undesirable migrants. On the flip side, citizenship by investment schemes are all about decreasing the amount of time you need to be resident in a territory in order to get citizenship. And there's a whole industry now, a quarter of the globe sells citizenship. And it's this, kind of capturing of high net worth individuals for whom paying a higher premium can decrease the amount of time or eliminate residency requirements altogether while giving someone citizenship. So again, thinking about spatial borders, temporal borders, but also the shifting border. And so when we talk about today, states externalize, we're really talking about sometimes variation, subnational variation in which kinds of institutions within the state are externalizing. So executive branches are really important in this story. And this is kind of going back to Torpy and the idea of this being a key notion of sovereignty, even in liberal democratic states that have robust sort of division of power and branches of government. We often see the discretion over who can enter or exit as being this protected domain of kind of plenary power, where courts potentially have less sort of oversight over these kinds of questions when it comes to national security and when it comes to migration, and the two are often intertwined. So they become kind of states of exception when it comes to these particular domains that courts have in general. Often we'll talk about some variation, but may even say we don't have jurisdiction in this area. So we're talking about executive branches, and then we're talking about border agents, Coast Guard, but also consulates abroad. And that's another way of thinking about these exterior controls and remote controls, is the way that pre-authorized or authorization for travel happens far away from the territorial border of the state. We'll unpack this a little bit, but there's variation in how different courts, especially in advanced liberal democracies, have reacted to this shifting border, especially when it comes to externalization. And we also see externalization being combined with delegation of border control to non-state actors. So we're going to talk about this in a little bit more detail, but we see private companies, deportation, private detention centers, but also on the flip side, and thinking about accelerated entry, visa processing centers, which is a huge industry now, where you have private companies like VFS, which takes people's biometrics and processes visas ahead of time. And again, thinking about this interplay of time and speed of access, if you pay higher premiums. I mean, the VFS even has a VIP package where they'll come to your house with a biometric device so they can take your fingerprints from home as if it's like a manicure or something. So, paying higher premiums can speed up access to things like authorized entry. Also, again, I mentioned the citizenship by investment industry. So there's all sorts of private firms that now consult high net worth individuals around different citizenship programs as a part of this idea of wealth planning and financial planning and planning for the future. We'll also touch a little bit about agreements with third-party states. This might be offshore detention centers, or actually, which won't come up later, so I'll just unpack, is extraterritorial borders. So since we're in the United States, I'll use it as an example, but the US border also exists in Ireland, in the Bahamas, in Canada, and in Abu Dhabi. And these are spaces that, almost like embassies, are considered the sovereign domain of the United States. There are border control, US border control in these locations, and you actually pass the regulatory framework of the border externally in these locations. So I'll stop there and transition over.
Thanks, Nora. Is this working? Okay. All right, great. So I'm really grateful that we were allowed to go first, because we actually kind of pulled things back. Our wonderful colleagues are going to talk about implications, ways around, solutions, grappling with these things. But this conversation between the two of us started in a cab at the International Studies Association in
2018?
No,
No,
2015 in New Orleans, where we took a cab together back to the airport and started going off on this stuff. So now we have an audience. So, but we have thought a lot about this, because if you say border externalization, the political science, or actually the sociology question, and sociology and political science question, is who had the authority? And it's states. States have claimed or hoarded the authority over borders. Torpy says that, Weber says that, over territory, they have claimed it. The peak claiming of this was the 20th century. And we collectively, and this Sawyer Seminar Project, have observed that there's some movement away from that. And so we're trying to give a bigger picture, longue durée, about the who's doing the externalizing. And there we go. And then the why and how. And so that's what we see our question as today. So Nura just went through the who. The who is states, and then actors coordinating with states. But states had that claim to authority, and they're the ones at the center of the giving away of that authority. We think that's interesting and important because it leads to a puzzle. The puzzle is why. States do not typically carve out, diminish, or lessen their own authority. Okay, it remains a massive puzzle. And we think we have we move towards actually some hypotheses about it. So why would states do this? I was just thinking about it, theorizing in my mind while Nura was talking. Well, the externalization of border controls in places like Ireland, that emerged kind of post 9/11. Is it security? Is there an effectiveness or an efficiency question about why? Is it linear? Is it like, oh, that's the way the world works better, don't worry your little heads about it, or are there benefits to cooperation with third parties that are quite legitimate, that where states can't handle border control anymore, so they have to externalize it? I'm using air quotes because I don't believe any of that, and some of the arguments and the hypotheses that we've worked on together, and I have a book project on, and we continue to work on elements of this together, is the evading accountability or responsibility. Something about the modern condition and the modern governing of this policy issue makes states want to evade their own authority or their own constituents or their own accountability. To whom? To someone. And so the question is, to whom? I have a couple quotes here. One is from Galia Lahab, who you're working with on a project right now. States shift liabilities outside of central governments as a way to diminish political costs and reconcile competing interests. So that's one hint, building up to a hypothesis about why. So there's something about intergovernmental relations. Nuda pointed to the executive branch. There's something often to the executive branch wanting to give away its authority. And also, and the second quote has to do with banking and finance institutions, but I find it quite useful on this topic as well. The blurring of boundaries between public and private renders opaque any political responsibility for the wrenching adjustments entailed in late capitalist development. So you can substitute late capitalist development for migration management in that quote if you'd like to. So bottom line, paradoxically, states are simultaneously reducing or moving around or hiding or dividing up some parts of their power, shifting it around, but to increase some kind of discretionary power over outcomes, okay? So the how. There's something about evading the accountability, and we've honed in on accountability to what or whom. Sometimes it's accountability to the public or the legislative branch or public inquiry. Sometimes it's accountability maybe to an international organization like the EU, but we found the most common denominator is that states evade their own migration laws, their own laws, responsibilities, processes, or constituencies, things states have codified in their own constitutions, policies, or rule of law. And so Nuda was going over the geographic or spatial elements of that. And that's kind of the conventional wisdom when we think about externalization. It's a geographic feature. It's not wrong, but that's not all there is to it. So she also mentioned the temporal element of that externalization. You can push something away in time to get it away from you in terms of evading accountability. But we also wanted to cover 3 other mechanisms. The 3 are distance from the legal controls of your own state. And we don't mean geographic distance. We mean sovereignty distance, distance away from the reach of the laws. It's not necessarily geographic. Also delegation to third states or international institutions and privatization to non-state market actors.
Oh, okay.
You have it attached to you.
Okay.
I knew this would be moderately awkward on my part.
Hopefully you
Can you hear her? Okay. Do you want to just shift this back and forth? Okay, that's a lot easier.
So when we're thinking about this, like a movement away that's not just geographic, it's a movement away from the regulatory power of different aspects of especially advanced liberal democracies. And later on, we'll kind of talk a little bit about variation across regime type, but I think it is important to sort of pay attention to the fact that some of the states that are at the forefront of developing these technologies are advanced liberal democracies that have robust infrastructures in place for things like holding the executive branch accountable, for example. And so when we're talking about the extraterritorial reach of the legal regime, it can be about evading the state's own commitments to international laws that have already been baked into domestic laws, or a whole variety of other kinds of rights that are baked into sort of membership rights and citizenship rights. And so it becomes kind of clearer sometimes when you're talking about interior controls of how you're sort of evading membership rights and domestic laws. But Jackie Stevens, who runs the Buffett deportation clinic at Northwestern Law School, for example, has worked on cases of trying to, sue the US government for deporting people who are US citizens, but are racially profiled and not given enough time to show documentation, and so therefore are deported, right? So these kinds of mechanisms, both in terms of exterior and in terms of interior, can be all sorts of ways of evading things that under the mantle of the law should be protected. And so we have an article called Muddying the Waters, where we're kind of talking about the regulatory authority of the state, specifically in the high seas, which is supposed to be a global common that no given state has sovereignty over. And we argue that kind of the shadow of hierarchy there, the fact that states, this is not clearly the jurisdiction, the territorial jurisdiction of a given state, actually increases the discretionary power because of this argument. And the courts have interpreted this differently based on which court you're looking at. But the basic argument is, if you don't touch ground, then you can't claim asylum. And so migrant interdiction policies or pushbacks, as they're often known, are ways of preventing people from reaching the territory of the state and having access to that right. And so the 1993 Supreme Court case, Sale versus Haitian Centers Council, really affirmed that it's an interesting case where the court is willfully saying we don't have jurisdiction if it doesn't touch ground, versus the European Courts of Human Rights, Hershey-Jama versus Italy, where the European Courts of Human Rights basically try to argue that, you know, jurisdiction follows the border, the Coast Guard, right? So that this is still illegal. Even people should have the right to claim for asylum. And I know we're going to be hearing from Isabella and also Susan, so I won't, they know that, especially Susan knows the law a lot better than I do, but there's this interplay between judicial branches and executive branches. And I think some interesting cases where the courts themselves are saying, this doesn't count as our territory. And we talk about the high seas where you're pushing outside. There's also examples like Australia where the border has strategically bleeded inwards, where it's excised part of its territory to say, even if you touch ground, you know, I can't remember what the exact measurement is from the border zone, but even if you touch ground in this territorial border zone, that doesn't count as Australia when it comes to claiming asylum. So this kind of playing with the spatial borders is also really about playing with this regulatory power of the state, of the legal regime.
Great. So this piece, I fought with a bunch of people when we were trying to get this piece published, because people would say to me, even migration scholars would say to me, oh, liberal states interdict migrants in the high seas because that's where migrants go, because they've been forced to, because it's so dangerous. And our argument counters that, because we actually show through variation in regime types that democracies are the most likely states to do that. And over time, there's variation in when democracies do it. And I'm previewing our argument, and it's when their courts have set higher standards. Other parts of the government then try to evade those standards by evading them jurisdictionally. So another mechanism is externalization as delegation. Delegation is when states either transfer some of their sovereignty away to another political actor. It could be a domestic political actor, like an executive agency or something like that, or when they share control over some policy through an international regime. So classically, European states have delegated some power to the European Union in different domains. Delegation can also be then to other states, and we're talking about things like the EU-Turkey deal, the Italy-Libya agreements, the US America's collaboration migration management strategy. And so often delegation doesn't stop there. Things get then doubly delegated to illicit non-state actors. Why does this matter? Because we care about the evading accountability mechanism of why things get externalized in the first place. Externalization is not usually a one-off move. It usually sets off a process of further externalization to watch for. Also, things get delegated to supranational actors like the EU. And then what's interesting in terms of accountability is things get double delegated, if you think of it in a political theory way, to an executive EU agency like Frontex, which has almost no international legal standing and almost no chain of accountability from European citizens or democracies to the outcomes. So when I say there's no chain, it means that no one in Europe, even politicians, can kind of undo what they've done or change it or shape it, because it's just this like creating a bot and letting it get out there in a way. I don't know what the right metaphor is. It's hard to rein it in or control it or shape it or undo it. But our argument is that's useful to states, and you have to watch for the conditions under which it's useful and why states decide to remove their power, undo it, give it away, and then let it lab leak out in a way that can't be controlled. The last mechanism is externalization as outsourcing and privatization. I was going to give my whole talk on this, but we decided to kind of combine things thematically and make it a bigger conceptual talk. And that is similar to delegation in that it's states giving or taking some of their power or sovereign authority over something, security, movement, regulation, and creating a contract and having a private firm carry that out. And so a lot of the logic here in a unified way is similar. Sometimes people have argued that outsourcing is done for efficiency reasons or for capacity reasons. Most of that has little evidence and has been debunked in multiple sectors. That most of the time is not true. People still go around believing it, but public policy studies have shown it to not be true. And so you have then our favorite hypothesis about evading accountability. So in my 2017 book, I show that the EU border security regime was shaped not by migration crises or by even the direct preferences of European member states, but by private security, actually private defense company lobbying from 20 years before to look for markets to justify the sales of additional defense and security products. And so what that does is it's a little bit of an accidental outcome, but not really, because even when European states were saying, should we do this? Should we have EU border security be about firms providing product platforms that are surveillance, like space-based surveillance of the Mediterranean by like Leonardo, a defense firm in Italy? At the time, political actors were saying, and that might be useful to us because it means we won't have a human-based search and rescue function where we could be held liable and accountable for lives. Okay, so it's actually a triple delegation to the EU, that sovereign authority over movement, then to Frontex, and often then from Frontex to corporate security contractors. Frontex itself has taken on functions that are sovereign in terms of being able to make agreements with third-party states and being able to arm itself with defense equipment. It's had that since 2008 and 2011. And then an ongoing project right now, we're about to wrap it up, I think we might be over time, is I'm doing the research right now in collaboration with Isabella and an undergraduate researcher, but we're taking this argument and looking at migration detention. I've been working on this for about 5 or 6 years, but the privatization of migration detention in both the US and Europe. We look at, we're currently looking at a hard case of Italy, because Italy has had very public sector control historically over migration detention until very recently, when it has outsourced migration detention like its neighbors in Italy, Switzerland, Austria, the UK, Germany a little bit. And the question is why? And I have a huge amount of empirical variation on this that all aligns with our favorite argument. And that is that, for example, in the United States, a migration detention was preceded by a rise in prisoner lawsuits, or a rise in lawsuits or efforts on the part of migration rights groups to expose the treatment or bring transparency to migration detention so that it gets privatized and outsourced. Also, a rise in FOIA requests and legislative inquiries precede migration detention privatization. And then in the Italy case, it looks like a rise in the politicization of the issue and big public exposés of the treatment of migrants preceded contracts being given to private companies. Okay, so we've already kind of covered this. This is our last slide. We think that this variation allows for social science hypothesis building and testing. There's cross-national variation. We see that this activity is more common in liberal democracies than authoritarian regimes. And also that amongst, over time within states, that there appears to be a push-pull or a cat and mouse game between the elements of states and the branches of governments, where if a state decides to start making its laws more progressive or migrant friendly, or actually enforce its laws better, that's where you see externalization often. And so that's it.
Yeah, I'll just say on this last note between liberal democracies and authoritarian settings, I mean, this is a very kind of depressing talk, but I also want to like emphasize that these are man-made rules of engagement, and the violence, the pattern, they're not inevitable. This isn't violence of the border. It's okay, I don't know where I was going with that framing, but different kinds of border control incur different kinds of violence, different types of patterns of violence. And so just looking kind of cross-regionally, the three largest migrant receiving regions are North America, Western Europe, and the Arab Gulf states, which actually accept a higher proportion of migrants from the global South than either North America or Western Europe. There's different patterns of violence because the system is structured differently. So in that system, you're really talking about temporary work authorization. There is no framework for asylum. People do not get extra rights by touching ground. You can't, and so in some ways, it doesn't function in the same kind of as the same kind of like incentive to arrive irregularly. You get extra rights if you can kind of touch ground. In some ways, the very idea of creating these havens, but then not giving people secure pathways to flee under duress creates this magnet where people are taking these journeys, not because that violence is inevitable, but because of this interplay of, on the one hand, promising rights, and on the other hand, putting militaries in place to prevent people from accessing those rights. You don't see the same kinds of pressures in Saudi Arabia or in the other Gulf states, which are actually also receiving really large flows of migrants, because over there, you kind of don't have rights either way, right? You don't, there's no promise that if you touch ground, you have this access to asylum. So
there's no cat and mouse game.
There's
necessary.
no same kind of cat and mouse. That doesn't mean those borders aren't violent people, and there is an irregular migration or embedded labor that can turn into trafficking. I'm just pointing out the variation in the types of border violence you see. Okay, we'll stop there.
So you did, yeah, go ahead and do prefer that one. Yeah. Oh, I can use this one. It's okay.
I don't know if that was working. I couldn't really go through it. Okay.
Thank you for this wonderful introduction. This is working? Yes. Wonderful introduction. And I think I'm actually so much happier that this is what you presented, because it really gave us the basis to then continue our conversation and kind of move into the more specific ways in which borders are externalized and how. And I'm here today. I'm really thankful to be here today. I'm going to talk about what does border externalization look like at sea. In particular in the Mediterranean Sea, where I worked with a search and rescue NGO before starting my PhD in 2017. So what does border externalization look like at sea? How do we draw borders in a space that is impossible to govern, that is so expands, it's such a large expanse of water that it's even an oxymoron to think about the sea and a border, a physical border at the same time. So I'm also a big fan of Shahar and the framing of how it's not so much thinking about people moving to cross border, but borders moving to exclude or include people. And here's some example of what Noor and Kaya were saying, the representation of the Irish border in Dublin that you mentioned, or the bleeding inward, the constitution-free zone in the United States, and the latest Italy-Libya meeting that there was just recently last week. So these are certain ways in which externalization can look like. But how does it look like in a space like the Central Mediterranean? And I always like to put the entire map when I talk about the Mediterranean to show how actually different routes are. We have, and you can see Morocco to Spain, it's actually a very small piece of the sea that people need to cross the border. Same with Greece, a little larger, but a different coastline that has more islands, and so a different kind of crossing. But then when you look at the distance between Libya and Italy, or Libya and Malta, it's actually an expanse of 290 kilometers to cross. So when I was thinking about this, I started thinking, so how can we trace borders in such a space? And of course, there is an answer of this in international maritime law, according to the 1982 Montego Bay Treaty, or UNCLOS. We have the division between territorial waters and international waters, which is according to international law, the space of jurisdiction, of territorial jurisdiction of a state that goes up to 12 nautical miles from the baseline, from the coast. So what happens in the rest of it in the international waters? And as you were saying before, we have international waters that have gone from being the common good to being considered the no man's land, where states can push their activities to avoid responsibility either put in place by others or by their own laws, national laws or international, like in the case of the European Union. So how does it look like when we talk about migration, when we talk about crossings? Where, well, when we think about that space, we would say, okay, migrants need to cross from Libya, so exit their border and cross the sea to then cross the Maltese or Italian borders of territorial waters. But a boat like this one, or a boat like this one, that is overcrowded and unseaworthy, very, very rarely makes it to shore. This photo in particular is the, it's not this boat, but it's a boat like this one. There was a big shipwreck in 2013, sorry, off the coasts of Lampedusa, where hundreds of people lost their lives. And it's really the incident that kicked off Operation Mare Nostrum at the time, which I will go into more detail later. That kind of shook Europe. So when we look at the map, when we go back to the map, we see how this is a map that MSF put together. It's updated to 2020. This is where most incidents at sea happen, whether they're search and rescue or interdictions. And I'm going to go into more detail later. Because the difference between search and rescue and interdiction is really where the border lies. So we're not just talking about a physical border, we're talking about a legal border, a border between the application of international humanitarian law and the not application of international maritime law. And here I brought the definitions, where we have search and rescue, that is an operation where you search the boat in distress and then you rescue. And I stress the emphasis on this because in order to rescue someone, you need to not only recover them and offer basic assistance, but also disembark them in a place of safety. And the definition of a place of safety is a bit ambiguous in international law, but it is a place where the basic rights of the people can be respected. And while that seemed pretty straightforward, it is not so straightforward when we think about the fact that the people who are being rescued are actually potential asylum seekers. So parts of their rights, according to international law, are also include the rights of having a fair asylum hearing and even just applying for asylum. And that's where it gets tricky. So when we think about search and rescue, then we think about, okay, then really the borders at sea are not just the international waters. Maybe the borders at sea are the search and rescue zones where states intervene at sea to rescue, recover those people. But that is not so much the case because very rarely do boats filled with migrants actually make it to cross past the Libyan SAR zone that was self-declared in 2018. And yet some people make it to Europe and some people don't. So it's not really the space that is important in this case. It is, again, who saves it. So when we talk about the borders in the Central Mediterranean, we talk about the intersection between international maritime law and international protection of refugees, where not only do we need to look at the right to disembark in a place of safety, but the right to have access to asylum. And most importantly, the right not to be refouled, not to be sent back, not to be pushed back. That's the word that's more common. And this is where my research comes in place, where I theorize that actually the borders at this point follow the boats that perform search and rescues in the Mediterranean, because as you can see, a boat in distress, and here's a definition of boat in distress, once they're picked up by European boats, and by European boats, I mean NGO boats or private boats, then there's a chain of international obligations, the duty to render assistance, the duty to disembark in a place of safety, and a place of safety being somewhere where the principle of non-refoulement and their access to asylum is respected, makes it so that the moment that you encounter someone in need of rescue at sea is the moment in which the migrant encounters the border. And on the other side, on the flip side, we have when a boat in distress is met instead in the same spot at sea, in the same international waters, in the same search and rescue zone by the so-called Libyan Coast Guard, then once they're met with them, they're sent back from the place they're fleeing from, and then sent back to detention, and then they have to pay ransom and go back, as it's been put together by several international organizations and even the UN. So how does that explain what's happening then? If we assume at this point that the place in which the migrant meets the border, the European border in this case, is the boat because of the application of international law, then we can understand better the way in which the European response has been shaped throughout these years. And so here I put together a timeline of the scope of European operations at sea. And here we go also into the privatization, I guess, of search and rescue and pushbacks. And we see how the first response of the European Union and Italy in particular was Operation Mare Nostrum, the first one on top, where the scopes were safeguard of human rights, comply with search and rescue obligations, and committing human smuggling and trafficking. And then just 1 year later, this was in response to that shipwreck that I showed you. Just 1 year later, the operation was shut down. It became a European operation, a Frontex operation. And slowly but surely, we start seeing how the safeguard of human rights and compliance with the search and rescue obligations completely disappear from the scopes of these operations, all the way to 2020 with Operation Irini that gets to the other extreme, countering terrorism. But that also shows how actually the search and rescue NGOs at sea, so the private actors at sea, had to fill that space more and more, while at the same time being criminalized. This is a visual representation of the search and rescue boats and aircraft that's present at sea at the time. And we see how from 2014, the response went all the way to 2016 with about 12 search and rescue private search and rescue boats at sea on top of the European efforts, that then started being criminalized more and more to go all the way to 0 during the pandemic. And that is inexplicable. Why wouldn't a European state want help in safeguarding human rights at sea off their own coasts, which they did in the beginning, as we can see from the increase, both from the increase of the number of NGOs at sea and the collaboration that there was between states and the NGOs at sea. Well, the answer then, if the border, the point at which the migrant meets the border is the boat, is the deck of the boat, wherever they are at sea, then that explains that search and rescue NGOs become very uncomfortable border outposts at sea, where we don't want them to be out there. And in this case, we want them to be as far away possible from the international waters where they can meet migrant boats. And here we go back to what Noura was anticipating earlier, the difference between the interpretation of these laws, the interpretation of the non-refoulement principle, which is really where this interpretation makes a difference in border drawing at sea, where we have in Europe, the more recent Rackete cases, but the core Hirsi, Jama and others versus Italy case that really sets in stone the fact that the country that has, or the boat or the captain that has the de jure and de facto application of the law on the boat is who's responsible for non-refoulement in that case, or for pushing back people from the countries that they're fleeing from. Whereas in the US, we have the exact opposite interpretation that actually comes out to the same policy outcomes of the law, where the principle of non-refoulement is not applicable extraterritorially. So American Coast Guard that retrieves someone's at sea, not rescue, retrieves someone's at sea and brings them back to wherever they're fleeing from, that's actually not considered refoulement according to the US Supreme Court. And this is a photo of me from when I was at sea. I'm going to pass the microphone to Susan, who's going to continue the conversation about access to asylum in safe third countries. Thank you.
I hope you can hear me. Oh, yes, the mic is working. Well, these are very difficult acts to follow. I'm going to take a slightly different lens. And since I was given about 9 minutes, I've drastically simplified a paper that Elizabeth Ruddick and I published last year in the BU International Law Journal on safe third and first country of asylum agreements. And I'm calling this Fortress Europe and Fortress North America in terms of border externalization agreements. And I'm going to talk about very specific type. Today, 104 million people have been forcibly displaced worldwide due to armed conflict, persecution, human rights violations, and violence. And this is about 1% of the global population. But the massive displacement has a very disproportionate impact on different regions of the world. Today, over 80% of the world's forcibly displaced population is hosted in the least developed or middle income countries. There's only one European country that is among the 5 majority refugee hosting countries that is housing over 1 million refugees. So Turkey has received more refugees than any country since 2011, even since the Ukrainian situation, and it has hosted over 4.5 million refugees. Turkey signed an agreement with the EU in 2016 that requires it to prevent refugees from moving on to Europe. This agreement, which rests on the premise that Turkey is a safe, and I'm going to use Kaya's air quotes, safe country of asylum, is one of now over 18 agreements between EU member states and refugee hosting or refugee producing countries that are designed to ensure that refugees remain in those countries, do not move on to the West or the global North, or can be returned to those receiving countries. The reality is that the majority of displaced persons are forced to stay in protracted situations in countries least able to provide for them for reasons that include border externalizing agreements, such as that between the EU and Turkey. So wealthy countries across the global North have been increasingly implementing systems, you've heard a lot about them this morning, that remove or turn back asylum seekers reaching their borders without considering their claims for asylum or for international protection. Europe has instituted policies such as the Dublin Regulation, which allows European states to require that refugees apply for asylum in the first European country that they enter, or others like the EU-Turkey and EU-Libya agreements that require those countries to put measures in place preventing refugees and migrants from trying to leave for Europe or to accept them back if they arrive in Europe. Similar to the EU-Turkey agreement, Spain's agreement with Morocco requires Moroccan police to block refugees and migrants and prevent them from entering Spain through Ceuta and Melilla. The UK's Nationality and Borders Act and the recent amendments to Denmark's Aliens Act incorporate provisions that allow both countries to send asylum seekers back to countries such as Rwanda, deemed to be safe for refugees. In our hemisphere, safe country policies include the Trump administration's asylum cooperation agreements, ACAs, or safe third country agreements, the STCA. So far, there have been 4 such agreements between the US and other countries, with Canada, Guatemala, Honduras, and El Salvador. But these complement a large number of both pre-existing and more recent policies put in place both before and during the Trump administration. These include metering, the migrant protection protocols with Mexico, the transit country asylum ban, the prompt asylum case review, the humanitarian asylum review program, ignore the names, they have nothing to do with what they're actually accomplishing, and the policy known as Title 42, and those are naming just a few. The Biden administration has not reversed the majority of these policies, and all are designed to prevent refugees and asylum seekers from crossing the US border or accessing asylum procedures in the United States. The Refugee Convention and Protocol are the main widely adopted treaties determining who is a refugee and the rights to which refugees are entitled. These include prevention against expulsion if they're lawfully present in a state's territory, and protection against return to a country where their lives or freedom would be threatened, the bedrock principle that everyone has mentioned, non-refoulement. Despite countries in the global north, particularly Europe, being parties to both international and European treaties, requiring them to provide basic protections and access to asylum to refugees and other forcibly displaced people, this framework of human rights is being eroded by the safe country, formal and informal agreements with countries at the periphery or outside Europe or North America. Though all these policies and agreements have important differences, they rest on the premise that neither the Refugee Convention nor international, regional, or domestic human rights law prohibits such transfers as long as they are to a safe first country of asylum where the individual had access to protection, or a safe third country where she or he would in theory have access to protection in the future. Though the Refugee Convention and Protocol do not prohibit agreements requiring return or transfer of refugees to a country where they could have sought or had sought international protection, there are fundamental requirements for such agreements to be consistent with international law. To be consistent with international law, each country has to make an individualized assessment of whether the country of removal can ensure, number one, that it will admit or readmit the refugee. Number two, that the receiving state will protect the individual from refoulement. Number three, commit or ensure providing access to a fair process for determining refugee status and meet other protection requirements of the Refugee Convention. Number four, that the individual would be able to submit in the receiving state his claim for asylum and remain there while that claim is being processed. Hence, the individualized determination to be a refugee and to be eligible to be granted such status exists for every single state party. An ongoing concern repeatedly expressed by UN bodies has been that these kinds of transfers should not be for the purpose of burden shifting of refugee responsibility to third countries, while relieving the responsibility of a receiving state from providing this access to asylum and these minimum guarantees. One critical measure of whether effective protection will be provided by a receiving state is whether the state is a party to the Refugee Convention or Protocol or a treaty that guarantees these rights. Now, the European Asylum System, the CEAS, has adopted these criteria in its Asylum Procedures Directive, which gives states options to refuse to review asylum claims if the applicant has received protection in a first asylum country or could obtain it in a safe third country that meets these criteria. The safe third country rule, the safe country rule, incorporated into the EU-Turkey deal, has been criticized under these criteria and decisions. The EU-Turkey deal allows the removal of all irregular migrants who arrive in Greece after 20 March of 2016 to Turkey on the basis that Turkey is a safe third country. In exchange, the EU committed to accepting more refugees from Turkey and to ease visa rules. In fact, the statement fails the test of individualized adequate assessment of potential violations of asylum seekers under the Refugee and the European Convention. By including a presumption that Turkey is safe, it bypasses the reality that Turkey's accession to the Refugee Convention only recognizes European asylum seekers as refugees, has no asylum process for non-European refugees, and most recently has initiated what it promises to be massive returns of Syrian refugees. Said this year that he's going to send back 1 million Syrian refugees to northern Syria. The US and Canada's Safe Third Country Agreement of 2002 has also been the subject of challenge. Refugee advocacy organizations in Canada have twice filed claims against the Safe Third Country Agreement on the basis that the US is not a safe third country for refugees. The cases rested on arguments that US policies, some of which I've mentioned, towards refugees, including widespread, systematic, and arbitrary detention, expedited removal, the one-year bar to asylum, criminalization of asylum seekers, the combination of national origin and religion-based bars, the so-called Muslim ban, violate the non-discrimination and non-refoulement guarantees of the Canadian Charter of Rights and Freedom. In both cases, the Canadian federal courts found for the applicants, but the Supreme Court of Canada reversed. The Dublin regulation explains why the migrant and refugee crisis is primarily concentrated in the border states of Italy and Greece, and why countries in Europe's center choose how many they will accept for relocation under Dublin, so that the central states of Europe have externalized their obligations to the periphery. At the same time, the proliferation of safe third and first country of asylum policies have been achieved primarily through individual bilateral country agreements, which the European Court of Justice has ruled it does not have jurisdiction to review, since these are not EU agreements per se, but are within the purview of individual member states. Thus, whether safe first or safe third country agreements actually comply with the required minimum conditions of international refugee law can only be adjudicated in individual situations, probably in domestic courts, or by the European Court of Human Rights, not the EU court, but the European Court has addressed specific cases, not the legality of the agreements per se. As for the US and Canada, there have been minor successes in rolling back the safe country policies and agreements for many reasons, which we can talk about, but they primarily include the reluctance of US courts to assess them under international law, and that actually better explains the outcome in the Sale case than suggesting that there was a parallel international legal analysis in the two different cases, Hersey Jama and Sale versus Haitian Centers Council. The rising number of safe third country agreements illustrates why the global north is reinforcing the image of Fortress Europe and Fortress North America, and why thousands of migrant and refugee deaths and disappearances in the Mediterranean, on the Central European borders of Hungary, Austria, and Poland, and the US southern border will only continue to rise. These deaths and disappearances are not accidental, but the foreseeable consequences of well-planned, deliberate externalization policies of the global north.
So I'd just like to say to all of you that I'm delighted to be here. It's wonderful to be on the same forum with my wonderful colleagues, my esteemed colleagues, with whom I never get to interact quite this way. So it's really a terrific thing for me. I'd like to also say to all of you that I am going to approach this subject from the perspective of experience, of my own experience. I think you know that I was a diplomat. I spent time working on refugees in Geneva, where I was the humanitarian counselor and then the deputy permanent representative. I was also what we call a refugee coordinator, the senior coordinator for Iraqi refugees and internally displaced in Iraq itself. And then from 2016 to 2018, I was the Deputy Assistant Secretary of State for Population, Refugees, and Migration, and had in my portfolio the entire US Refugee Admissions Program, US RAP. So I'm still going to try and make sure I'm responsive to what we're talking about. And I'm going to address this question of externalizations based on my experience, which has to do with the practical aspects of how we have dealt with crises and how our laws have been plastic or maybe plasticized. But even more shocking, I think, how bureaucracy itself has been used as a means of creating artificial and perhaps unintended, as far as our law goes, barriers. I'll be dealing mostly with refugees, not asylum seekers. But you know that the difference between refugees and asylum seekers is actually what you might say a nice distinction. Asylum seekers are in the United States and refugees are outside the United States, but our laws are very similar in the way we apply them. So let's go to our first slide, if we can. Oh, I do it.
Yes.
Oh, how wonderful. Okay, I'm going to call this talk How Global Crises Have Rocked American Refugee Admissions from Vietnam to Ukraine. And I want to say that if you're here, you're probably an idealist. I hope so, because you should be an idealist if you care about humanitarian issues. And idealists probably imagine that policy and law are developed on refugees to address humanitarian issues in a rational, efficient, and effective way. Okay, not so. For most of the United States history, we have not had refugee law. In fact, the word refugee, I think, does not appear in American law until about 1948. Until that time, our borders were, to different degrees, largely open. And that changed over time. And there was no special arrangement to deal with people who were persecuted. But if you are, if you're me, or if you're anybody working in refugee affairs, should I stay there to stay on camera? Yes, I should. Working on refugee affairs, you're haunted by that picture, which many of you know. That's the St. Louis, a refugee ship that came to the United States in 1939 with Jewish refugees from Europe who were fleeing and were turned away. About half of them made their way back to Europe and were exterminated. And that hangs over everything we do in the United States government, the memory of that lapse. You see a picture here of Eleanor Roosevelt and FDR. Immediately during the war itself and immediately after the war, not only were decisions made arbitrarily, they were made personally. The intervention of Eleanor Roosevelt herself, a single person, made for the rescue of certain numbers of refugees. But the numbers were I think, frankly, shockingly low. Shockingly low. This is really interesting how this works. I do want to say that I'm going to have to accelerate all of this, I think, because we're going to run out of time. So I'm going to accelerate. There's a history of NGO involvement. And there's Edith Terry Bremer, a visionary catalyst who supported women and refugees early in the 20th century. But it was really the response to the Holocaust that started to create real refugee law inside the United States. And in 1948, a law was passed to permit about 350,000 displaced persons from Europe to enter the United States. It was aimed particularly at victims of the Holocaust and of other persecution. But we saw other things happen along the way that were responses to very specific crises. One of them that you see here is the Hungarian Revolution of 1956. Again, a certain number of refugees, I think it was about 56,000, were permitted into the United States based on a single and specific legal provision. And that provision did not stipulate clearly what would happen in terms of status for those refugees after they entered the United States. When we think about externalization, I'd like you to think about a different mode of externalization, which I think my colleagues have already mentioned. Once you set foot in the United States, you may have a different level of status, a different path towards green card status, permanent resident status, or ultimately citizenship. And that in many ways creates a kind of internal legal border against the full rights of individuals who come in under different regimes. There is a picture of the airlift of Cubans to the United States. That was obviously associated with the Cuban Revolution, and it had the benefit of a large level of support inside the United States, but they also came in with unclear status. Everything changed with Vietnam. In Vietnam, the United States had a particular geopolitical interest in what we were doing and a sense, once again, of guilt that all these people that we had stood up for, many of whom had worked for us, were now at great risk as the United States left. And ultimately, we permitted into the United States over 1 million Southeast Asian refugees. But initially, they came in, again, on what is called parole, humanitarian parole. That gives you no status in the United States, no path to citizenship. But adjustments were made to permit that path to citizenship. What really changed was in 1980, with the support of Ted Kennedy, amongst others, the Refugee Act was passed in the United States, the first really substantial piece of legislation, and really the element of American law that should have, I think, dictated how we responded to refugees. Look at this beautiful thing here. The objectives of this act are to provide a permanent and systemic procedures for the admission to this country of refugees of special humanitarian concern to the United States. No reference to race, religion, nationality, region. This was a global idea. We used definitions from the 1951 Refugee Convention focused on persecution of people based on race, religion, nationality, political or social group. We developed a system within the United States government to determine ceilings to let refugees in, and created a public-private partnership led by the State Department, but including HHS and the Department of Homeland Security to administer all of this. I'd like to say, to some respect, it worked. Many of you have seen this chart, I think. That's the US Refugee Admissions Program. And admissions, the colors show different regions of the world that refugees come from. What you see is a response to crises. First, Southeast Asia, boom. Next, the fall of the Soviet Union, boom. Next, you see the wars in the Balkans. Then you see all the problems in the Middle East. And as it should be, the colors change because the victims of persecution are different. It seems like we're in a situation where we're actually trying to do something that is neutral. But that isn't what happened. The story kept going. And instead of using the Refugee Act of 1980 to deal with following crises for a variety of reasons, can't go into all of them, we did individual one-off legal interventions. The Mariel Boat Lift of 1980, the Lautenberg Amendment of 1989, which applied principally to Jews and Christian minorities from the former Soviet Union and Iran, although that was folded into the US Refugee Admissions Program. 1967 Nicaraguan Adjustment and Central American Relief Act, which tried to clean up some of the mess of folks who just had humanitarian parole, and the 1990 Haitian Refugee Immigration and Fairness Act. And then came the global war on terror. What do you folks think? How did George W. Bush respond? Did he block refugees from the Middle East? Well, the answer is yes, for 90 days. And then he reopened it. And under George W. Bush, things tightened up, and there's lots of scholarship behind this as to what happened. But I want to jump ahead to my favorite. There he is, Donald Trump. And President Trump is holding up there one of his executive orders, and this is the one putting a 120-day ban on any refugee arrivals in the United States. And I was then Deputy Assistant Secretary of State, and I fought with, I can't say with him, mostly with Stephen Miller, over how all of this would be implemented. And what they said is, we want extreme vetting. Extreme vetting, well, we went along with it because, frankly, we're civil servants. Diplomats are civil servants too. And it's not up to us to violate the policies laid down by our political leaders. assuming they're legal, constitutional, and ethical. That's actually a bit of a bar, and that created problems along the way. So what happened? We put on layers of, in many cases, redundant and useless levels of vetting insisted on by DHS and by the White House. But we all thought it was workable. And then it turned out not to be workable because the administration then withdrew all the people who were doing the vetting from the agencies involved. So there was no one to do it. The FBI had one person doing the vetting of all refugees in the world. What happened? Well, one of the things that happened is that Afghans who tried to come into the United States through the Special Immigrant Visa Program, another one-off law to try to protect Afghans and Iraqis who had worked for us, and which I administered in Iraq and also worked on in Washington, suddenly came to a standstill. The backup became an 8-year backup. People ask, why were those people clinging to the tires of that plane in Kabul airport? Why didn't they come in on the SIV program? Well, there are a lot of reasons, and I don't want to say it's just this. But one reason was that a bureaucratic obstacle had been erected specifically to stop Afghans from coming in. And that was done under that administration, the Trump administration. Since then, things have changed again. And under the Biden administration, as you know, there was a large group of Afghans, 74,000, who were evacuated. The vast majority of them arrived also on humanitarian parole, which put them in a legal limbo, and they're still in that legal limbo. There is a draft law to try to regularize their legal status in the United States, but it hasn't gotten any traction. And then President Biden also opened up, I think you'd have to say, immigration really, but I'm not sure that's the right word, for Ukrainians, and something completely different happened. They were again let in on parole with no legal status, although they're getting different elements of legal status, no pathway to citizenship whatsoever, and a 2-year time limit. This creates a border inside our country around Ukrainians who've come here for fear of war, persecution, and death. The final piece I want to talk about, and I'm going to end right after this, is the southern border. The southern border has changed everything because people can walk across the border. And what we're seeing is another effort to try to create layers of bureaucratic externalization. And the piece that I find the most interesting is that there has been an effort to create a law to keep people from coming to the border, to provide 30,000 entrants for Nicaraguans, Cubans, Venezuelans, and I've left one out, can't remember. This is an effort to keep them away from the border so that we don't have to deal with the question of non-refoulement at our own border. I'm going to end just by saying that there's some obvious conclusions that one can draw from this record of American engagement with refugees. One of them is that the admission of refugees to the United States is, always has been, and I'm afraid always will be, both political and humanitarian in its nature. And I keep trying to drive this home with students. Don't forget it. Political interests are going to apply. These political interests are not just one thing. They're geopolitical interests, but also domestic political influences. Who in the United States can make the case for their relatives overseas? And all of this results in episodic policy, which is staccato. Pieces are not attached to one another. They're not rationalized. What does it mean systemically? We have the excessive use of parole, which creates classes of refugees inside the United States with different levels of rights. Refugees end up in a legal limbo, which means they are open to possible exploitation. And we see the United States' reputation in the world suffering. So is there an alternative in an era of fractured politics in America? I hope so. But right now, the Biden administration has put forward a revamp of our immigration law. It's going nowhere. The Bush administration tried to do it. It didn't get anywhere. And I don't know if anything, will break the logjam. Thank you.
We know how to use this. Found.
Now it's on.
Does that work?
Yeah. So we're
Okay.
gonna stop share so that they see you.
Yes, I do.
And they'll have a better picture of you.
Okay. I can see the time there.
See you.
Oh, they're seeing me from
They're
there.
seeing
Okay, no problem. Sorry about that. Can
Nope,
you
no.
see me now? It's provocative and challenging to enter this discussion at this moment in light of the realities that have been documented and theorized about here. Thank you for having me here. Thank you for creating this location, for all of you who have created it. I look forward to the discussions. So I'm coming at things a bit differently now, and I'm very cognizant of the tension or the discord potentially between what I'll be talking about and what we've heard. Although I also know there are many people here who see them both at the same time. So I've been thinking for a while about a project that's taking shape now. We don't quite have a title yet. I came up with the title of Less Violent and More Porous Borders, Ideas and Practices, Reforming Borders, Opening Borders. We're working on that. I'm directing it together with Kaya Shielda in ongoing collaboration with Elizabeth M. Ryan and with the participation of many people in this room. The project's just beginning, and we really welcome ideas and suggestions. So if after hearing this presentation, you have thoughts about how we might proceed, please get in touch with me or Kaya or Elizabeth, or stay today for the workshop that we're having here at 1:30. I'm going to say a bit about how the idea for the project developed and what we're hoping to do, at least as we envision it right now, and this is information. For the past 25 years, I've been teaching a course called US-Mexican Borders. The course begins by looking at the physical border historically and proceeds as it moves toward the present to expand both the geographical border and the notion of what and where borders are in both the US and Mexico and in recent years in Central America. One thing that's become clear to me as I've developed this course, become clear over time, is that we've come to have a great deal of material, written material, visual material, testimonies that illustrate the difficulties, pains, and horrors of deciding to leave Central America or Mexico, of journeying across Mexico, and of crossing the border and then trying to survive in the US. This wasn't always the case. There wasn't always so much material. It's the heroic work and scholarship and activism of many people that has made that so clear. These horrors are clear to academic audiences, as well as in some locations in the media and politics among more or less liberal and left publics. And the focus and theorization about externalization here sort of adds to that and deepens and takes in another direction, lets us see other aspects of those horrors. What I found, however, is that after people note the horrors happening at the border and say that these need to be changed, what follows is very limited. Academics tend to look toward what it might mean to think beyond borders, of a world of open borders and different understandings of citizenship and its relationship to race, gender, sexuality, and violence. And I want to say as clearly as I can from the outset that I am deeply respectful of and engaged with that kind of work. It's one of the things I do want so much to be part of. It's a central part of my teaching, helping students, encouraging them from within their own research and that of others to think about other futures, other ways of being. So I'm not in any way discounting or putting aside that and what I'm going to say next. Non-academics, friends, other people I've talked to tend to shrug and say, after recognizing the horrors, tend to shrug in some way and say, but there needs to be a border, which functions as a sort of conversation stopper, a retreat into any number of assumed truisms regarding legality or economy or culture, along with the assumption that some kind of national legal and political solution needs to be found, however unlikely. This is my personal take there needs to be a border to mean, when pushed to its logical conclusion, here I'm being a bit facetious, is this, that a more compassionate US would set up the equivalent of a network of comfortable hotels, daycare centers, and health clinics along the border, so that migrants who reach the border could live in comfort and security, with 95 or 95% of them then being sent back to where they came from or put on impossibly long waiting lists. In other words, what are we and what are people thinking when they they simultaneously say, this is awful and needs to be changed. There needs to be a border. We can't have children in cages at the border. What comes next? So this project, the one we're beginning here, is about how we, migrants, activists, policymakers, academics, citizens, teachers, caregivers, might begin to fill this empty, not really, but seemingly empty political and imaginative space. How might we publicize in the case of practices that exist or develop through discussion among ourselves and with others? How might we publicize or develop alternatives that are or might conceivably function in the world as it is now or as it might be in the foreseeable future? Very complicated categories. What are experiments in different border and migration practices happening? And what are our experiments in different border and migration practices that are happening? What do they look like, or what might they look like? Now, what would be words for this? And here is one of the places of complexity. Practical is one word, practical alternatives. But I worry that the connotation of that is one of limits of accommodation to the status quo. Though practical need not mean that. Think perhaps of John Dewey's pragmatism. Workable. Unconventional economist Albert Hirschman spoke of and embodied a passion for the possible. That's a quote, based on the belief that what is possible changes and is created. I'm not necessarily comfortable with any of these words. And particularly, I don't want to, well, I'll get to this. Another word that comes to mind is reform. And I'd like to talk about that for a moment, since it gets at the idea of what I'm thinking of, even if we choose not to use the word itself. A few years ago, I co-directed with Vivian Bennett a 3-country, 5-case project called Enduring Reform. The project was about private sector responses to working examples of progressive civil society-based reform. I'll return to the business part of this in a moment, but I'd like to elaborate a bit on what we meant by reform, because we really struggled over that. We used the phrase significant reform. We meant things that the group of us involved in the project or hypothetical others would agree were not, on the one hand, band-aids, small changes that served obviously to uphold the status quo, or on the other, transformative or revolutionary changes that we might speak for or like to envision, but they were unlikely to happen in a short-term or foreseeable way. And again, I don't want to foreclose thinking our activism toward transformative or revolutionary changes. By significant reform, we came to mean locations of change that took up residence within, but ran by different logics and principles from the environment in which they were embedded. Examples of what we meant in that research project included worker-run factories in Argentina, participatory budgeting neighborhood practices in Brazilian cities, and indigenous self-reliance networks in San Cristóbal de las Casas, Mexico. And just to give one example, a worker-run factory was seized from the owners. Political activism got that seizure to be legally recognized. They were run non-hierarchically by workers themselves, but they functioned within and sought to function within the existing market system, whatever their long-term goals. They wanted to buy and sell successfully so as to support the workers in the factory. So the idea of calling this a significant reform was that something significantly different was happening. Again, we could discuss, is it different enough? What does difference mean? And I do note that in the context of externalization regimes that are noticing that some things that look like reforms are actually externalizations, that complicates the sanctuary cities or other things people mentioned, that complicates it even more. But I'm proposing that we need to and want to think about a category that has that meaning, even if we call it something different. So the idea of the Borders Project, whatever we call it, is first to find, examine, and publicize working examples of alternatives or experiments that promote less violent and more porous borders in a practical or pragmatic or passionately possible or significantly reformist way. And also collaboratively to imagine and outline other alternative policies or practices that could do so, if the conditions for them could be fostered. So it's finding what's out there and imagining what could conceivably be out there. The first stage of the project has involved looking for existing alternatives. And this has brought many fewer examples than I'd initially expected and hoped for. And that might mean I'm not looking in the right places. I've talked to a lot of people in this room and elsewhere, including academics, activists, and artists. I've encountered immediate understanding of and interest in the project, but very few examples of practical reforms, if I may use those words for a moment, either in the world or in people's scholarly artistic imaginations. Tiana Kupik, in the back of the room, who's been a research assistant for the project, has had a similar experience in doing bibliographic searches. And when Kaya and I spoke with Alex Rivera, a filmmaker and 2022 MacArthur Grant recipient, he also had a lot of enthusiasm and few specific suggestions of where to look. So we want to brainstorm together to find out what is out there, to imagine new projects or practices, and to publicize this realm of the possible. So let me just give you some examples of the kinds of things we have found or are actively imagining. The best example of exactly the kind of program we're talking about is the one that Susan Akram at BU Law School and Dorothy Estrada Tank from the University of Murcia in Spain have been working on, and which they presented at the first meeting of our workshop. And I'm not gonna, you can correct any missummaries, but the project involves an on-the-ground working effort to bring refugees to rural cities in Spain that need people or want people, focusing on how specific aspects of social, community, and economic life can function to incorporate and meet the needs of both migrants and the receiving communities. Again, apologies if that's not entirely accurate. The idea is this is a place where something is happening, where people are being brought in a way that will make a big difference to themselves and perhaps create a model, a logic that is different within a broader system. And then in the interest of time, I'll mention very briefly some of the others. I just want to explain that there are possible categories. Another example might be humanitarian corridors of the sort mentioned by David Suleski, I don't know how to pronounce his last name, at our meeting, where non-state groups, often religious groups, design new pathways of transfer and hosting that assure relative speed and safety outside of regular state channels. Where are those happening? You can find some on the web, that's interesting information. Where and what might that signify? Angel Cabrera, who was here but might not be now, suggested to me a possibility, not an actually existing thing, of legal strategies to hold corporations responsible for environmental harms in Central America. In the event of findings of harm, restitution might involve both financial transfers and access to residency in the US. That's hypothetical, but one could imagine the pieces happening. Emma Sokoloff-Rubin, my daughter, who runs the Urban Law Clinic at Yale Law School, suggested thinking about what sanctuary cities do and how this might expand. This would bring its own obstacles and oppositions, but imagine a growing network of locations, small and large, that acted to change rules of policing, education, and healthcare, and the provision of documents like driver's licenses. Is that, what might that add up to? I myself have been thinking about circular migration, in which decisions about movement over the course of a lifetime would be made by migrants themselves. This was inspired by Alex Rivera's documentary, The Sixth Section, which details the circular migration patterns of migration and financial transfer. And I'm not going to go over the rest of what I said, but there's a lot of evidence that if the border wasn't as fixed as it was, a lot of people would choose to move back and forth, not weekly, but at different stages of their life, when their kids are a certain age, at certain patterns in people's work lives, that opens up. So what would an experiment in enabling that kind of movement mean? And finally, in another example, Nora Laurie and Kaya Shielda have observed two things about the private sector, mixed in with what you've observed in a different way today. That businesses are often skilled at vetting and moving people, and that the private sector historically has not been uniformly opposed to immigration. And here I'd circle back to my Enduring Reform project and book, in which we found that in rapidly changing current circumstances, the responses of business people to progressive reform could not be predicted by conventional understandings of economic interest, but rather depended on cultural representations, timing, and context. So we might take from Nora's and Kaya's observations together with my work that the private sector could be a partner in innovative border openings. So those are what's come out of conversations. I don't want to privilege those. There might be reasons one or the other of those are implausible, but that's what we're trying to brainstorm about and invite more comment on, and then think together about how we might. It's essentially how to answer the question to prevent the shrug. Yes, this is horrible. What can we do? Well, look at this, look at this, look at this. This is working here, this is working here. Might that provide a different way forward? Thank you.
have been wonderful and rich talks, and I thank my colleagues so much for their comments and for sticking to time, roughly, generally. So we do have time for questions. Marina will be gathering any from the chat for our guests on Zoom, and I will be inviting a CFD person to move this this microphone. Thank you, Micah. In the audience so that our guests can hear those questions, which I will moderate. We'll have about 15, 20 minutes of these questions. And then as people are dying of hunger, please get something to eat. Sorry, Zoomers, we can't Zoom you any of our lunch. And then we'll continue the conversation over lunch. Okay. Who would like to start?
Well,
Go for it, Micah.
Great question. Yeah, it's just probably.
Notice.
Alright. It's for Susan, a clarification question. So I think you mentioned this, but who determines whether a given state qualifies as like, safe? So I understand that there are legal standards, but it's a question of who ultimately determines whether a given state meets those standards. And then on top of that, is there any form of judicial or legal oversight about that determination at a national level or at an international level?
Yeah, very good question. So it depends on the type of agreement. And for example, I mentioned the UK Borders Act and Denmark's new borders legislation. In those two pieces of law, what the countries have done is to incorporate a provision that says that each country can draw up a list of countries that they determine are safe. Now, both of those countries have to conform to the European Convention on Human Rights, which has non-refoulement criteria and other human rights guarantees in it. The ultimate adjudicator beyond the domestic courts when those challenges take place would be the European Court of Human Rights. And we heard about at least one very well-known case, the Hersey-Jama case, which is a European Court of Human Rights case. EU states are bound to the EU asylum directives. And as I mentioned, the criteria, the bedrock criteria that are the normative criteria are built into the EU policy directives. So the ultimate arbiter of those decisions and agreements should be the European Court of Justice in Luxembourg, a different court. But if those are bilateral agreements, and the European Court of Justice has already told us it's not going to accept jurisdiction over those because they don't consider them EU instruments. So it's up to domestic lawyers in pretty much every case. That's the first challenge and ultimately the most reliable challenge. So the same is true in the United States. And we have a different problem here in US adjudication of these kinds of agreements and all of the policies that I've talked about, which is that the US does not directly incorporate international law in the decisions on asylum and refugee claims. And in fact, the Sale case is a perfect example of how backwards, from our point of view as international lawyers, how backwards US court decision-making is, because it looks at international law from the point of view of how it has been adapted into domestic legislation. And there's not always a good fit. And in the Sale case, there was clearly not a good fit between the US's obligations under the refugee protocol and the domestic incorporation of that, the provision that was being interpreted. So really the ultimate responsibility is on domestic lawyers. That's where it all rides, and we can't rely on the international, regional, or other court systems to be a really strong or robust check on these agreements.
Can I add to this? And actually, in addition to the way it works, if we apply the same at sea, then in practice, and we go back to what Mark was saying, the adjudication of a safe port, so a place where people can be safely disembarked, technically falls under the Search and Rescue Coordination Center that responds to the search and rescue call. But what's been happening in the past years is that for example, the Italian Search and Rescue Coordination Center in Rome assigned Tripoli as a safe place to disembark people who were fleeing Libya in the first place. But that then leaves the practical decision in the hands of the captain of the boat or the search and rescue coordinator in that case on board to take the responsibility upon himself or herself to disembark people in a place that is safe. And the problem that the impasse that's been happening is that Rome says, bring them to Tripoli because that's a safe port. And then the captain says, I can't rightfully bring these people to Tripoli or other places because I can't assess whether or not that is a safe port for people who are fleeing from that place.
I had one tiny
Yes.
comment on this. Just to say that the UN High Commissioner for Refugees will have an opinion
Yes.
on whether or not a particular location or port is safe and meets the standards of the 1951 conventions, stipulation against non-refoulement or stipulation for non-refoulement. But UNHCR has no juridical power to decide anything. They are a voice crying out in the wilderness.
Is it on?
Yes.
Thank you so much. I have one question. I guess it will be for Professor Rubin, and then another question comment. It sounds so academic. So the question is, how do you imagine, I mean, I really like the idea of circular migrations, but the question is, how do you imagine them legally? I know how you imagine how people would move, but would that mean that it would include a different kind of visa that we have to think about? Or how would you solve it, like between countries agreement, between visas and whatnot? The second comment is, like, maybe it's a little bit naive, but I was wondering about like border corruption cases, because it's like, I mean, I can talk one about the border. I know that's between Serbia and Hungary, which is like a really weird space. So what about smuggling and all the corruption cases on actual physical borders? How that's fit into this whole talk about changing borders?
Thanks. I have not and do not have the capacity to think about the details, although I think they're really important, and that's actually what we would be doing collectively if we were doing it. What the idea of circular migration comes to me from kind of experiences of other people and myself, and seeing a reality that is obscured by the hardening of the border and the rhetoric on each side. And that reality, and here I'm drawing on the work of political scientist Judith Hellman, who did extensive and wonderful ethnographic interviews with migrants. This is back in the late 90s, early 2000s. So a lot of the conditions are superseded. But she, not surprisingly, found people who were constantly moving for reasons, making decisions. This is when the border still allowed back and forth, when it might take a few tries, but there wasn't the level of violence and predation, and there wasn't level of difficulty. And she had really interesting conversations of women who were deciding what mattered to them about their autonomy as a woman was served in the United States or at home. They were talking about children, people who wanted their children to be educated in Mexico, not in the United States. There's of course many examples of people who do come to the States for reason, who have reason to want to go home as well. Again, this is mitigated by issues of violence, but a very different notion of what that might look like. And Alex, in his film, The Sixth Section, showed not only how groups, he drew a map at a wonderful point in this film he was looking at hometown associations, that groups of people, in his case in Newburgh, New York, who got together and sent resources back to their community of origin in Mexico. And he talked about the patterns of movement back and forth, the way people who could cross the border were bringing materials back and forth, kids were going back to the places of origin. And that got me thinking, what about investment opportunities, business? How many kids growing up in Newburgh might also be interested in creating, and he gave examples of kinds of businesses, as did Judith Hellman. So my anthropologist sort of community-based head, along with theirs, was thinking about how might that foster a very different understanding of what the border is and how it might function. That obviously doesn't pertain to locations of extreme violence or war zones or things like that. So what I would like to take this forward is as nobody knows who would go back and forth and how and in what ways. There might not be a problem, at least in certain countries. I don't want to be, it wouldn't only work if there wasn't a problem. I don't want to ride this notion on the fact that it would all work out perfectly, but it would be worth finding out something about. So I'm wondering, is there some way of an experimental program or a pilot program or some group of people who could be, and again, I'm not talking about seeking permission to move back and forth. So the grounding for thinking about that, I think, is solid. How it could happen, I don't know, but I don't want to stop and think, oh, that's not possible. How might it be possible?
Puerto Rico is a little bit of an example.
And thank you, Liz.
In some areas of the world, circular migration is simply a common thing. So before the most recent takeover of the Taliban, the Afghans have been moving back and forth between Pakistan and Afghanistan forever. I mean, the border that the British drew, the Durand Line, had absolutely no meaning whatsoever to the Pathan populations on both sides. And the tribes have continued to move. And even during the height of fighting, Afghans would move to the Northwest Frontier Province area until fighting had died down, then go back and for their crops and harvest or replant or take care of their families and then come back again. The same has been true of Syria and Lebanon before 2011, before the civil war began. Porous border across the Bekaa. And interestingly enough, in both of those situations, again, it's not about legal status. It has nothing to do with the offer or ability to access legal status. Pakistan is not a party to the Refugee Convention, so they have housed millions and millions of refugees without an international legal obligation to do so. Same with Lebanon and Syria.
I see Mohammed has his hand. Can I just answer the trafficking? I wanted the second part of the question. On the first part, I think we have other examples. We also have historical examples. I mean, there's an interesting article by Fortes et al. I wish I could remember the exact title, but they actually show quantitatively that irregular migration hits a spike after this kind of hardening of the US border, and that the existing programs that were seasonal had the similar people being able to go back and forth and not overstaying, but once you eliminated those programs, people could kind of go home. And so it's heightened border controls that actually force people to stay where they might not want to stay and they want to actually go home. On the point about criminalization and like sort of leakage in these, passport supply or other sorts of irregularities at these border zones, I think that it's really hard to disentangle illicit from licit chains. And partially because, as Isabella sort of experienced on these search and rescue missions, as we know, Sada Mardini, who now has a movie on Netflix, The Swimmers, a young Syrian woman who actually came here to BU and she gave a talk. was doing search and rescue, and she's facing criminal charges for human trafficking. And so often this idea of trafficking can be levied against search and rescue. That's the first issue. The second issue is that often when it comes to migration chains, it isn't really clear that who the illicit versus licit actors are. And you can have, like, I know it best for thinking about the Gulf with Asian countries, but you can have there's a real black box when it comes to these migration intermediaries, all of the manpower agencies. So you might have an authorized agency that then has sub-recruiters and sub-recruiters who are not authorized, or an authorized agency that might have illicit activities. And so I think it's so, we want to sort of think like, these are the criminal, this is human smuggling, and this is trafficking. Here are the victims and here are the criminals. And the practical unfolding of that on the floor, on the ground is really difficult to disentangle.
So,
30
on to Susan's point, I mean, the Taliban government still doesn't recognize Durand line. I mean, the Durand line, I mean, so I was in Pakistan last week, and people in the military told me that they've lost 500 people just last year alone trying to build a border wall. So that even the government of, I mean, any Afghan government has never recognized it. Now, you also have to remember that this predates the creation of Pakistan, right? So it goes, Durand lines was built in 1893. Pakistan was created in 947. So no Afghan government has recognized that. So there's even a state-sponsored support for that circular migration back and forth. And Taliban on both sides, actually, one of the issues is getting rid of that. So even at that level, the circular migration in some cases is state-sponsored. And Afghan governments, whether they are on the left of the political spectrum or more conservative like Taliban, don't recognize that at all.
I just wanted to add a brief response in addition to the other fantastic responses about illicit activity. And Nuda had a fantastic response about the nuances and the weaponization of smuggling versus trafficking. But I also wanted to pick up on what you said about corruption, like payments happening, illicit actors. That is a little bit of a different category, but I reject outright any analyses that say, oh, this area is corrupt, or it produces corruption, or it's a prior condition or an organic condition. I think that it's easy to make an argument that states produce the frameworks for both licit markets and illicit markets based on the severity of their border regime. And so, for example, all this outsourcing and privatization creates licit markets that have interest in perpetuating this and whose activity varies with the amount of state interest and funding. And the same thing with illicit markets. They aren't being necessarily directly paid by the state, but their markets are perpetuated by the degree of the robustness of the border regime. So I would look at that for understanding illicit activity. Yeah.
Marina, any questions from the Zoom?
Yes, actually, there's one that I think was directed to Jeff, but it potentially applies to everyone. And it has to do with labor migration, which you also touched a little bit upon. Thank you. But this person is saying that they were interested to know a little bit more about the US situation as it compares to Spain and how the community's lack or need for additional labor is then managed in the light of these restrictive policies that prevent people from coming in. So they were interested in hearing from Jeff if he has any interesting examples from other places that could maybe be applied in the US. But I think it would be interesting to hear from others if you have comments about this too.
Well, in fact, I think Susan may be able to speak to that better than I can, especially articulating the differences between why there's an opportunity in Spain and not in the United States. And that was part of our previous discussion, but I think the next step in our discussion and where many of us wanted to take your work and think about it comparatively is there are neither the legal instruments that are available to communities in Spain, nor the sort of clear, as I would designation of sort of emptied or sort of closing down rural communities. But in terms of the need for labor and the fact of growing migrant communities that are documented and undocumented in the United States, I think that's one of the places where business interests could be brought in and community interests could be brought in. And I think what we're trying to think about is what would it mean to create an alliance and some kind of pilot program or look at programs that exist that say, here are business needs for migrants, here are communities that already have sort of migrant networks of incorporation and support and care. How might that be formalized in some way? So again, it wouldn't look like Spain at all, but it could say, here are multiple needs of different constituencies, an existing set of needs on the part of business, resources on the part of existing migrant communities, potential for other communities. What would it mean to make that possible, and what might that look like? I don't know if you want to add to that.
So a couple of the big differences between the way immigration and asylum operates in Spain versus the United States is that the US's asylum policy, other than overseas refugee policy, is very much part of the immigration law itself. The 1980 Refugee Act is part of the Immigration Nationality Act. And so provisions, part of the challenge is that that is all nationally very tightly controlled. Even though you have adjudicators across the country, it's a national immigration, part of national immigration policy. Spain comprises independent autonomous communities, and they have a great deal of autonomy in deciding who to integrate in their areas. And Spain, interestingly enough, Spain's Ministry of Immigration is the same ministry, it's the Ministry of Immigration and Inclusion. And all of the autonomous communities can accept migrants, refugees, and then allow them a pathway to permanent status on their own. It's not governed by the national policy. So there's a great deal more room for autonomous communities to decide whom they want and how they want to integrate them in their communities, what jobs they want to offer, how that process will work. So there are opportunities that are simply not available here in the US for that kind of sort of independent decision-making on immigration, migration, and refugees. The second piece I wanted to say is that in the US, you can remain here for decades and, as you mentioned, still have no pathway to legal status. We have 11 million undocumented people, something like 85% of them are working. We know that. They all have jobs, they have families. The average, the most recent study I've looked at, the average undocumented person has been in the United States 10 years. And so in Spain, they would have a pathway to permanent status. Here they don't.
I wanted to comment again, but does anyone else want? I don't have the legal expertise to talk about what might be possible or not, but to bring this back to the project I'm trying to articulate, to move into that space where multiple people on different sides of the US, sort of different locations say, but what could we do? There has to be a national solution. This is terrible, but what would it mean to create answers to that? So one beginning answer might be, look at these communities in Spain. Here's, bracket the legal difference. Here's an example of a European country with borders and various kinds of tensions and issues where a coalition has come together between law and communities and activism to create a different way of accepting people. And then the next question could be, where might we see ingredients for that? And just imagine it. Imagine ingredients like that in the United States. Here are migrant communities that have existed for a while. Here is work that people are doing. Here is an example, say in Maine, of programs that are bringing together kids whose families are from Maine for a long time and migrant kids and trying to get dialogues going. Think about community reception. Could we imagine a way towards seeing those ingredients and then begin to ask the questions, which are, and again, those questions can be huge, but can there also be an imaginative capacity and looking at on the ground things that work to say, and again, bringing in the private sector and say, how might interests or be refashioned or coalitions be created or even images given of this works here.
this is happening here, how can we pull that together? So I want to hold both of those questions at the same time, why things aren't possible and you know, what is could or is happening.
I'd just like to add that we are seeing some elements of this in the evolution of US refugee policy, even though it's not always strictly under refugee law, with the use of sponsors for people coming to the United States, particularly Ukrainians, or the 30,000 under this law related to Nicaragua, Cuba, Venezuela, and the other country I can't remember. If you're, yes, of course. If you're coming at it from my perspective, having worked on the US refugee admissions program, you actually see a danger of corruption and exploitation through the introduction of the idea of individual sponsors. And part of the reason I say that is, again, I look at it from a bureaucratic perspective and a structural perspective. We don't have enough people to monitor all of those sponsors. Are they actually providing what they were supposed to provide? Are they asking something they were not supposed to ask? Are they working with people overseas who are middlemen? And this is not to suggest in any way that the idea of engaging local communities isn't, to me, extremely appealing, but it has to be done in a rationalized way. And better, I think, for it to be through communities and through civic organizations than through individuals.
Just a quick mention that in Spain, it's not individual sponsors, the community sponsorship. So the municipal governments are the ones responsible for the agreements between the national authorities. And then, and because Spain has had this integration program forever and ever, there are NGOs that are so experienced with working on this for migrants. So scaling up to overseas refugees is not a problem.
Yeah, and I think this actually, Susan's project might actually be a way of also learning from other experiences that do exist in Europe. Like, for example, the Italian integration system that does work on small towns. Like I used to work in one of them that, well, that say we can integrate 5 families and have them integrate there, but it has 2 aspects that maybe have signified the, I'm not going to say the failure, but maybe the not best success of the integration of these people. One is the temporal factor. So the fact that the users, I'd say, of your new system would be already recognized refugees instead of people, asylum seekers, waiting for their asylum to be recognized. But also the fact that it's a decentralized system versus the centralized version in Italy that doesn't feel forced upon communities for economic opportunity or forced on the migrant population that is being sent to these small places in Italian mountains.
I'd just like to reflect as we move towards more informal conversation and refreshments on something I've been noticing as a continuity across these amazing presentations. And it really is a reimagining of where the border is. So for Isabella, the border is the moment the search and rescue boat finds the migrant. For Nora and Kaya, I was thinking multiple places, but the border is the moment that you make an agreement with Frontex, and then the border for Mark was the moment of geopolitical crisis, and then the response, the political response to that constructed in ad hoc moments in the history that you showed us, or it's the domestic lawyers in the court. And so if we've had the border reimagined in so many different ways, I could just leave with some hope for Jeff's project that we can renew, we can reinvent, reimagine in some practical sense, a different version of how a border could operate and be constructed. It's so clear the border is not that line drawn on a map, but it's functionally many, many different things. So let's make it the right kind of different thing. Okay, please continue conversation. Enjoy some lunch in the back. And thank you so much for your great questions, your great presentations, and for your presence here today. And please join us for future events. There's a flyer in the back as you leave.
And where are the workshop if the people are staying for the workshop?
If you're staying for the workshop, we'll be here. We'll transition in about a half hour.
It's like all of my notes are asked me about this.
The new
Asked me about this.
The new
At-
global-
To have a one-on-one conference.